there is no judicial review clause in Article 3. That's a really, really important point that people need to focus on and remember. And in that respect, the U.S. Constitution differs from the post-1945, post-World War II constitutions around the world. They have judicial review clauses, and they usually only give to one entity, the Supreme Court or the Constitutional Court, the power to enforce the Constitution. Under the U.S. Constitution of 1787, the power of judicial review is an implied power. The implied power of judicial review does not include an implied power to evolve the Constitution or to engage in living constitutionalism. In fact, the text of the Constitution specifically bans that. Article 5 of the written Constitution specifies a very onerous process for amending or changing the Constitution, whereby one needs the approval of 2/3 of both houses of Congress and 3/4 of the states, which today means 38 out of 50 states. The Supremacy Clause of Article 6 says this Constitution, the laws made pursuant to it, and all treaties made or which shall be made are the supreme law of the land. Well, that means the Constitution and laws made pursuant to it are the supreme law of the land. There's nothing in there about Supreme Court precedents being the supreme law of the land. Under our Constitution, as it is written, with the power of judicial review being only an implied power, the Supreme Court simply only has the power, and in my opinion only should have the power, to enforce the text of the written Constitution and its amendments against unconstitutional laws or acts of the President or acts of the states.